Thank you so much for coming, for being out here in Wyoming, or coming out as the case may be. My name is Lewis Cohen. I'm a co-founder of DLx Law, which is a law firm based in New York, Wilmington, Delaware, and Washington, D.C. And my co-founder, Angela Wilson, is actually in the audience. So if I do anything like really dumb, she's going to yell, tell me what the heck. That's always good to have your co-founders with you at all times. I'm going to talk today about NFTs, and I think there's already been a number of talks about NFTs. And I think one of the things we're going to talk about is why I'm talking about NFTs. Because this is like, why is it that, going from 2 years ago in 2019, when I was privileged to be out here in Wyoming for the hackathon, then there was just almost nothing on the subject. People were interested in layer ones, a bunch of different things. DeFi wasn't even really relevant. And it seems today, if we're having a conference on blockchain and exactly what blockchain means, you can't do it without having 5 or 8 or 10 talks on NFT. So I want to talk about why that is, and then a little bit with my own perspective on the subject, and hopefully help educate you guys just a little bit. We're live streaming, of course, but we can manage to take questions as we go. I'm open to taking questions if there's a point that you think should be elaborated on. That's not a problem. I think if we wind up getting a little bit bogged down in questions, I'll ask to hold them toward the end a bit more. But if it's something that you think others would be interested in, questions somebody else does too, happy to kind of jump in and take those questions also. Obviously, this is a talk on law, so there's a lot of technology that is involved, and I'm sort of far from a technologist. But at the same time, I think if you are a lawyer and you want to practice in the space, or you are practicing in the space, it is really important to have a pretty good grounding in the underlying technology. There are areas of technology and law where the intersection occurs, and some knowledge is okay, but you don't really have to be an expert. I would say in blockchain, it's really pretty important to have a good idea. One, it's such a new technology, and so a lot of people don't know what they're doing. And one of the things we do at our law firm very often is just try to make sure the clients that are coming to us know what they're talking about. And often that's a real question. So if you as a lawyer don't really understand the technology, when a client comes and says, I want to do A, B, or C, you may be okay, when in fact the answer should be, how is that actually going to work? And if you understand that. So I think it is important as lawyers, and let's get a quick show of hands, at least of the folks in the room here. How many of you are either lawyers or practicing or non-practicing lawyers? Just about everybody for those at home in the room, which is great. So I think that is important. And I always, when we talk about the technology, I really emphasize the importance of starting with Satoshi Nakamoto's Bitcoin white paper. There's just no substitute for having a very strong understanding of how Bitcoin works, Bitcoin blockchain, those principles. Everything else builds upon that. And I think even if what interests you are NFTs, if you're an intellectual property lawyer, you don't really want to do technology except to the extent that NFTs play into that, I think it's still really critical that you understand these technologies. As probably most of you are aware, NFTs, at least to date, have been mostly exist on the Ethereum blockchain. The Ethereum blockchain has both similarities to and important differences from the Bitcoin blockchain. Understanding what those differences are is really important as you dive into the subject. So just those are some preliminary remarks. If we're going to be talking about NFTs, there's no better way to start than what's an NFT? What are you talking about? And just inherent in that name, those initials, non-fungible token, is already a bit of a conundrum. Because you would think if something is non-fungible, there's only one of them. But of course, in many cases, NFTs are created where there's not only one of them. There's some limited supply, but that number is greater than. And once you have a number that's greater than one, you might ask yourself how non-fungible it is, because if you have 2, they're fungible with each other. And if you have 200, they're definitely fungible with each other, et cetera, et cetera. So the term non-fungible token has really come to mean a digital asset that is discernibly finite in number, but not so finite as to be just one. And all this does start to lean into some legal questions that can arise when we talk about NFTs. NFTs inherently are tied to what we loosely call smart contracts. And if at this point you haven't heard the name, smart contract is neither smart nor a contract, and please just because that's the starting point. But as with any at this point already cliche, there's a lot of truth to it. It's important to understand what is in fact a smart contract, because if you want to understand what an NFT is, you can't do that without understanding what a smart contract is. A smart contract is a bit of code, typically in a standardized format, that exists at an account address in a smart contract enabled layer 1 blockchain. So, for example, Ethereum, also Solana, also Avalanche, also any number of other blockchains. And these blockchains, unlike the Bitcoin blockchain, which really only can store two things, holding aside it's one thing very technical on me that's happened to upgrade from a week or two ago, which has changed things a little bit, but by and large, for the most part, the Bitcoin blockchain really just stores two things: a public address that generates a key pair with a private key, and a number. And that number, of course, is the number of UTXOs, very formal transaction numbers, but basically colloquial Bitcoin that's associated with a given address. That's all the Bitcoin blockchain. The Ethereum blockchain is capable of storing code in the form of smart contracts at an address that is on the blockchain. And that code can do more or less anything anything computer code can do, as most of you probably aware. The Ethereum blockchain creates something that's referred to as the Ethereum virtual machine, or EVM, and that is as if you were programming a real machine, but one that is distributed across nodes and runs deterministically across all the different nodes that are currently running the relevant client software. And that machine can and does regularly execute smart contract code. So in the same way, some of us looking around the room can remember when you had like your DOS machine, and I remember punch cards. I'll tell you that, dating myself. But in the same way that you run any computer code, the EVM can run code, and a smart contract is simply an example of code that can be run across the nodes of a blockchain. And for the most part, I'm going to be a little lazy here and refer to Ethereum only, but as I noted before, NFTs can exist on any smart contract enabled blockchain. So it's certainly not limited to Ethereum. If I slide back and just commonly referring to that, that's the most popular by far at this point in time blockchain. So a smart contract is code typically in a predefined format that exists at an account address on the Ethereum blockchain and is able to undertake various activities. And one of the things, and most important activity, technical term there, activity. But one of the most important things that a smart contract on the Ethereum blockchain can is point to an address. And so the most basic standardized smart contract for NFTs on the Ethereum blockchain is a format known as ERC-721. And that was developed by Dapper Labs in connection with CryptoKitties, which was one of the first real breakthrough NFT platforms. And it's really only about 10-ish lines of code, something like that. And it's a form. It's a form you fill out. You enter various variables. Like many forms, you can add to it. You can make it as long as you like. So there's no stopping you from adding additional code and additional things. But its basic format is very simple and straightforward. And probably the most important thing that it does is it contains a field for a uniform resource indicator, URI, that allows you to enter an address of a resource that's elsewhere than on the blockchain. This becomes really critical when we think about how NFTs are and how they work. So that URI, in the most simple and basic case, in terms of ease of understanding, is a address in the World Wide Web. So it's a www dot whatever address. And by pointing to that address, uniquely linking that address with that smart contract, it creates something that is somewhat magical, which is it uniquely identifies the resource stored at that address as the only resource that's linked with a, let's for the moment just say one-of-one digital asset. So transfer of the digital asset by means of the Ethereum blockchain, by giving an instruction to the blockchain to take the token emitted, if you want one, of course, the only contract, taking the token emitted by that smart contract and re-registering it at another address controlled by someone else or yourself, another address controlled yourself, effectively tells the Ethereum blockchain and anyone looking at a block explorer that, oh, this resource at that address, the World Wide Web address, is now owned by whoever's the account owner of the new address. And it's as simple as that. So we have public addresses on the Ethereum blockchain, again, something very similar to the Bitcoin blockchain. And there will typically only be one owner of that address, one person who controls that address. We'll talk about fractionalization in a moment because that is an important and complicated topic. But for the time being, that's all really an NFT. So it's a smart contract that exists on the Ethereum blockchain with a uniform resource indicator identifying some address, which may be on the web, it may be on another service, most popular, which you've probably heard of, is called the Interplanetary File System, IPFS. And IPFS is actually not a storage system, and I'll talk about that in a moment. We'll talk about persistence, but it's a way of finding resources. But it's a smart contract that identifies something. So that could be artwork. Many of you will be familiar, of course, with the Eagle artwork, 5,000 days. And that's just an example of a digital artwork located in a particular location. And you're able to say, if nothing else, anybody may have a copy of the artwork. It's very easy to find it online and print it out and put it up on your wall. But only one person can say, I have the digital asset that uniquely references that artwork. And so that connection, that reference is really what the NFT is. At the end of the day, it's a way of saying, I can look up in this registry, which is the Ethereum blockchain, and I can see that there is, let's just say only one NFT that references this resource. I'm the only person who controls the private key that relates to that token or that digital asset, and therefore I own that NFT. Critically, and hopefully somewhat self-evidently from the way I've described it, what you do not own is the underlying resource, right? So what you own when you own the NFT is really the ability to send an instruction to a network of computers that causes that network of computers to change one number to another number, one public address to another public address. That's what you own, the ability to give that instruction, that unique ability. Your relationship to the resource, artwork, music, other code, whatever it may be, is one that is set out elsewhere because the 721 contract typically by itself will not tell you what your relationship to that resource is. You need, most often, if there is something that is in the nature of intellectual property, most likely an artwork. But again, it could be musical work, it could be written text, it could be any sort of intellectual property, but you need a license, right? So someone out there who has created something that is intellectual property that your NFT is pointing to, someone out there controls the rights to that. Copyright is inherently granted to whoever the creator or creators of a particular work are in the absence of some contractual change to that. So I may create something, I may create it as a work of hire, or for hire, and then the person who's paying me may hold the copyright. I may create something and may assign all my interest in that copyright to someone else. And we recently saw, for example, examples in the musical industry where Bob Dylan and any number of other creators have assigned all of their rights in various copyrights that they own to companies that aggregate those rights and exploit them. But in the absence of something like that, the person who creates the work holds the copyright. If you buy an NFT and it points to a work and you don't have a license, you don't have anything. Now, there's an interesting question of if you don't have anything, but nevertheless, the creator sold you an NFT and took money from you for that didn't give you a license, what exactly is your relationship with that? That is a difficult question and one we're not going to answer right now. We have a question.
My answer is you get the same thing if you buy a CD or you buy a poster. You got the right to resell it, but you don't have any license to use it and look at it, but you don't have a license to the underlying copyright.
Absolutely. So the statement was if you don't have a license or you have a very limited license, all you have typically is the ability for non-commercial use, which is what you're describing. If it's an audio work, to play it. If it's a visual work, to display it, but for non-commercial purposes.
You can trade it though.
Well, as those who work with me know, I'm a super stickler for pronouns. So you just say it. So don't say it. So because there are two things, and it's important when we think about NFTs to distinguish.
We're able to transfer it.
So the it, remember, there's the NFT, right, exactly. So the NFT is simply the bit of code that has, and as most folks may know, if it's a one of one, you would have simply one public address, which would be your wallet address, right? So if the ability to transfer the token, really, again, just to be very, very precise, what do we mean is that you have knowledge of a private key that allows you to send an instruction to the Ethereum blockchain. The instruction says, delete my address as the registered address and move that to a new registered address, which is the purchaser's address. So that is functionally transferring.
And if somehow like the JPEG image that was tied to that on the IPFS server gets deleted or something,
No.
It's not your fault. I mean,
Well,
you have the token that says that you're supposed to be able to have access to that.
And in fact, it's a perfect segue because right down on my list, next topic, persistence. So thank you for that, because it's a great question of what happens if that resource goes away, which is fundamentally the question. So if you own an NFT, and again, be very careful with your own, what you own is the ability to transfer that digital asset that is part of a smart contract that points to a resource, right? Let's be super precise this morning. The resource, as a gentleman noted, whether there's anything there or whether there's a 404 not found is another matter entirely. And I think that brings up what I believe is one of the most important and generally overlooked issues in NFTs, which is who's responsible for persisting the underlying metadata. Now, if we think about in our real lives, right, we've got our phone and we take a lot of pictures of our family and loved ones, whatever we do with the phones. And some of those pictures are pretty important to us, and we have an incentive to want to persist that data to the greatest extent we can. So we know that if the only place that data resides is on a physical handset, and I lose that, drop it in the water, it's gone, I've lost the data, and that's what I'm sending to me. So typically what I'll do is I'll have some form of backing up the data, right? I may use the Apple service, the cloud system is, or some other service, so that I know this data is important to me and how badly I want to ensure I always have access to it. One way of backing it up might be just on a hard drive in my home. My home could burn down and I could lose my phone, even at the same time. How badly I want to protect that data is a decision I make because that data is relevant only to me. If I'm a company, it's a similar sort of pattern, except it's a corporate decision, right? I have customer data. How much do I want to spend? How important is it for me to ensure that the data is always available and doesn't get lost? Now, let's talk about NFTs using that model. It looks a little bit different. Because of the transferability of the NFT, you don't have one person, corporate or individual, who has a permanent lifelong interest in that underlying data. I might own the NFT for a minute, an hour, a day, a week, or a month. My enthusiasm for paying to ensure that that data is always persistent and always available may be limited by the fact that I make an assumption that I'm only going to own this NFT for a relatively brief period of time, and it's not my problem. The gentleman's question, whose problem is it? And that is a really open question. On some platforms, they will attempt to directly discharge that responsibility and say, you should know in buying this NFT that we take no responsibility for persisting the underlying metadata, which is really what you think you're buying, right? You don't really care so much about a token that points to nothing. So what you think you're buying is at least, as the other gentleman pointed out, if nothing else, the ability to non-commercially display the particular work and to identify yourself as the person who has that, right? But if the platform that sold you the NFT is not persisting the data, if the artist who created it persisting the data, probably not. They've sold it, they got their money, they've moved on. And so we have a real nagging question. And the thing is, and this is playing out in real time, and we represent clients that are thinking through these issues right now. The interesting thing is that data just always grows because the whole idea is that an NFT is forever, right? So we're all working on the assumption that as long as the EVM is being maintained by nodes, I should be able to have that NFT. And, if I pass away, I'll give it to my children. And boy, son, this crypto pump. It is your legacy. We expect that to go on and on and on and on. So the data is going to grow and grow and grow and grow. And as we look at other forms of data, that can become quite exponential and that can become quite costly. And you can rest assured that the nice folks at AWS are smiling about this. But the question is, they're happy to provide the storage, but somebody has to pay them. And they operate under the no taking, no laundry philosophy. If you stop paying, we stop storing. So that's a really interesting question. So I think that's persistence. Please.
You've been talking a lot about the smart contracts just kind of being linked. Would it be possible to say like mint a copyright registration and then have the smart contract say whoever holds this token is the holder of the copyright?
That's brilliant, and it gives me a great opportunity to shout out to a very dear friend and excellent lawyer, Diana Stern. Look her up, follow her on Twitter or whatever. So she did a project, I think working with the team at MIT, where she tried to basically embed a very basic license into a field of an NFT, such that if you acquire the NFT, you sort of take this license. It's a little bit of a question mark because you're not signing anything. It's not really a formal process, but it's probably a good bit better than a lot of anything else. So I think it's a great question, and Diana's a terrific lawyer working in the space. I want to segue a little bit to the topic of securities law, and that's a topic that's near and dear to me because that's most of my training and background is in securities law. And of course, I think all of you are probably aware that there's a tremendous sensitivity right now around the topic of digital assets generally. We'll come back to NFTs in a moment, but digital assets generally and securities laws. And the relatively new chair of the SEC, Gary Gensler, has made it quite clear in a variety of ways that, at least in his view, virtually all digital assets are probably securities. He's never quite come out and say that, but he's been pretty transactions are securities transactions and variations on that theme. That's the subject, sadly, for another discussion, but it contextualizes some of the concerns around NFTs. Whatever my particular theories are and those of others, the SEC is sort of like the umpire in baseball. And until, you go to the replay booth, which is, a federal court, their position stands up. And so we do have to respect, and there certainly is an intellectual basis for the position that they take, that most digital assets are securities. Now, we might ask, as we try to understand, what about NFTs? Are they securities too, right? We might ask ourselves, why does the SEC think that most digital assets are securities? Because if you don't know why they think that, then it's very hard to apply that rule to fund returns, right? And that, of course, is the now world famous Howie Test. And I actually had that tattooed on my arm. Most people, somebody actually said you did. Firstly, let's just say just a moment about the Howie Test, because it's really critical to understand in the context of looking at any digital asset. And I think as lawyers, a firm understanding of this will ground you very well. You work both in NFTs and with other digital assets. Although, lost in the midst of time, we had well over 100 years of securities law in the United States before the federal government ever got involved. And that was at the state level. Like many other things, securities was a state level matter, and state blue sky laws, as they referred, governed securities up until, the crash of 1929 and the recognition that a federal and consistent framework was needed. But for, the 100 years plus of securities, railroad bonds, and all those other things, state law applied. And state law in most states used a term called investment contract. And it's kind of a catch-all phrase, and it was not particularly well defined in state law, but at least some states had developed this concept more than others. When the drafters of the first federal securities law, Securities Act of 1933, came along and they started enumerating the types of securities that would be covered, they hit the popular, high points: stock, bond, certificate of interest, participation certificate, and a variety of other things. And they went through this litany of things that I think everybody would recognize. Okay, well, those are all securities. And then they drew from state laws, let's put investment contract in too. But they didn't define it, and so that left a rather big question. We kind of think, what stock is, what bond is, what note is. So what on earth is an investment contract? Of course, the case of SEC versus WJ Howie is where the Supreme Court weighed in and gave us the definition, which is now called the Howie Test, which of course, just to restate, just check on my arm there, it's an investment of money in a common enterprise with a reasonable expectation of profit, primarily from the efforts of others. So those are the factors. But it's important to understand, as we look at NFTs, what is that test trying to get at? And what the drafters of the 33 Act and the state legislators passed laws before, what they understood is that if the only types of instruments that were subject to securities regulation were the ones that kind of presented themselves as securities, well then, it would be pretty easy to work around this. And you could say, well, I'll come up with something else, and it's not quite, it's not a stock, it's not a bond, so therefore we're good to go, aren't we? So how do we recognize that? So there are economic relationships in which money is passing and expectations of profit are occurring that really should be treated as if they were securities transactions. They're commercial transactions. I'm selling you something. Howie, of course, they were selling orange groves and an associated management contract to manage the orange groves. But, over the course of 70 or 80 years, we've seen variation upon variation upon variation. But all of the cases involving the term investment contract have a common theme to them. The common theme is that one person is ostensibly selling something to another person. The other person doesn't actually want that other thing. What they want is just to make some money, and they expect to make some money by reselling whatever it is they got at a higher price, generally speaking, and the higher price is going to find itself through the efforts of whoever sold. So, I tell you, you could buy, 10 barrels of whiskey aging in, somewhere up in Scotland. And if you just hang on to it for 5 years, I'll resell it for you and you'll make a tidy profit of 15% a year. What's not to like? I'll even throw in a couple of bottles, on the side. Are we in? And they're 10 grand per cask. And this is, of course, a real case. And courts have said, come on. Nobody's buying the whiskey. This isn't a commercial transaction. People want to make a profit. They want to make a profit from the efforts of whoever is selling the cask whiskey. That transaction really should be registered with the SEC if you want to offer it to retail people so they can understand the risks that they're getting themselves into. So that framework, when digital assets started getting sold, mapped pretty nicely onto what was going on. People were selling fungible digital assets, wherever they may have been, and I won't degrade any particular digital asset by calling them out, but people sold digital assets in bulk. And the people who bought them, generally speaking, weren't expecting to use them in the same way that the buyers of the orange groves weren't expecting to drink the orange juice. The buyers of the whiskey cask weren't expecting to drink all that whiskey. Most of it, not all of it. And so the people buying the tokens were not really going to have a consumptive interest in what they were buying. What they wanted was to make a profit. And they, again, expected the profit to come from these sales. And so the SEC pretty aggressively got involved in the space. There's a much longer story to be told. They published a report called the Dow Report, and then they started enforcement actions, culminating in action against Telegram, the messaging service, who had pre-sold a lot of tokens, had developed the token and wanted to release the token to the purchasers. And the SEC successfully got a permanent injunction against that. The Federal District Court wrote a terrific opinion, I think, by Judge Costell, the most respected judges in the Southern District of New York, and explained that he agreed with the SEC's point of view. He agreed that when the digital asset was being sold, the purchasers really were not the end users. Their expectation was that they would resell it for a profit, and that's why they were in this. That the only, that the Telegram company had repeatedly stressed their expertise, that the only place that the profit would come from was through the efforts of the Telegram company, and so it fell squarely within the Howie Test. However, the court in the Telegram case did not have to cross the bridge as to what exactly was the security. The scheme, the arrangement was the security. There was the Telegram token, which was known as grams, was not actually ever released because of the injunction. And so we never had to cross the bridge on whether the gram token itself was a security or would trade as a security. That is now being litigated sort of indirectly in the case involving Ripple Labs Although technically the case does not involve the secondary market transactions, both the defendants and the SEC have sort of made it be about that as its own interesting story. So why have a 10-minute diversion on this? Because now when we look at non-fungible tokens, it's critical that we look at non-fungible tokens through this same lens, right? What is going on when a non-fungible token is being sold, and does it fall within this type of scheme? Now, in most cases, if you think of sort of a very run-of-the-mill kind of creator, someone who has toiled away doing digital art for many years and not recognized much money, but is very creative and has so uploaded their art to one of the platforms, let's see the most popular platform, somebody buys that NFT that links to that resource of this piece of digital art, and maybe someone later thinks it's worth more, maybe they don't. Maybe the person who's the artist does some modest promotional efforts, but nobody really thinks that this is a fundraising effort for that modest digital artist. But now let's look at other cases, and it gets a little bit more blurry. And I know one of the other speakers did a whole in-depth panel on a lawsuit that was brought against a company called Dapper Labs, which developed a very well-known platform, NBA Top Shot. But I think it's still, I missed that talk, and I think it's a really interesting case, and I think it's very illustrative of what we need to be careful about when we talk about NFTs. Alleged in that case, in the Dapper Labs case, is that the digital assets being created, the non-fungible tokens, which in that case link to a file that is maintained that shows a short video clip of action taking place in an NBA game. And the whole idea is, fans love to evaluate, this shot was better than that shot, that dunk, that this and that. And so people would have the pride of ownership of a particular moment in the NBA and be able to trade those and enjoy the gamification of ownership, which is as big a piece as ownership itself. The lawsuit alleges that because Dapper Labs chose not to use the Ethereum blockchain, but to develop their own blockchain, which has many advantages, and they call their blockchain Flow blockchain, the digital assets that they created were sort of stuck, for the time being at least, on that platform. And that really, if you look at it closely, what's going on is that the company, Dapper Labs, is raising a lot of money through the sale of these assets that nobody really wanted. Because frankly, if you want to find a clip of LeBron, dunking over somebody, you could find it pretty easily on the web. And so nobody really wanted. What they wanted was the number go up. And they allege in the lawsuit, at least, that the number goes up because of the efforts of Dapper Labs. Now, I don't believe that lawsuit is going anywhere for any number of reasons, but I think it illustrates the connection between the problems the SEC has with fungible tokens and the kinds of issues that can come up with NFTs. You have to look at all the facts and circumstances around how the NFT is being marketed, how it is being sold, and how is it being consumed. Is there a question?
Yeah, so Wyoming passed a law, I guess it was initially for utility tokens, now they're calling them consumable tokens. Can you talk about that concept? Is it literally just to avoid the whole security argument, and people avoid it when they're using it?
So the question is about amendments to the Wyoming law around utility or consumable tokens. That's a great question, and we're here in Laramie and very fortunate to be here. Wyoming has done a tremendous amount to help progress the discussion around digital assets, around blockchain technology, and around how that fits in with the law. And I think it's a great example of how leadership can come from states, even very modest-sized states by population. What the law seeks to do is kind of designate certain sorts of tokens as being clearly non-securities. And I think that's very helpful. It doesn't necessarily address the main problem that the SEC, particularly vis-a-vis fungible tokens, is concerned about. Because something can be completely developed and consumable. The question is, how is it being marketed and sold? So let's just say, for argument's sake, come back to our whiskey. And so we're fractionalizing a cask of whiskey, and the whiskey's already been matured. It's at 10 years, and it's perfectly ready to drink. Maybe it gets a little better if you leave it there to 15 years, but it's fine, and it's finished for our purposes here. If you were to sell a token that was a representation of the whiskey in a volume much greater than any one person or their business might consume, and if the expectations could reasonably be demonstrated to be profit-oriented from resale as opposed to simply owning it, And if, let's assume for argument's sake here, that the person's not in the business of being a whiskey dealer, which would change things, but they're just a private citizen and they're thinking about various investments. They can invest in gold or this or that or the other thing, but this whiskey thing, that sounds like a good deal. The SEC would say, even though it's consumable, even though it's finished, the nature and the facts and circumstances surrounding that still is more characteristic of an investment contract than not. So we have to be careful in not falling into the trap, and we try and tell our clients in this term utility. And many lawyers practicing in the space have the same phenomenon. Some calls like, well, I've got a token, but before you get going, it's a utility token, so you don't need to worry. But it's a great question, and to your point on the work that Wyoming has done, I think by pushing these points and drafting statutes, so not just talking about it, but as Samuel Clemens said, doing something about the weather, we can actually make a little bit of a difference here in Wyoming. So I think it's been great leadership. I don't think it completely solves the problem, but it's a step in the right direction.
Yes.
Please, yes.
Follow up. So what if you were trying to tokenize the chain of title for a piece of property? You could put on reference blueprints for the building and all that stuff. And all it really is a record of what I've done with this real estate.
Well, absolutely.
And would that kind of you're not trying to sell it, you're not trying to you maybe give it to the person when you sold the property.
Right.
And it's not being monetized. I mean, would that be a situation where you're not worried about securities because it's just information that's useful to have that is held by the property owner and going to be given to another person when they buy the house?
So just for everybody's benefit, especially those listening elsewhere, the question is, but okay, so we see a lot of tokens can be securities. What about something, for example, real estate or title to real estate, where the documents, the blueprints, other information are all associated with the NFT? Is that going to be a security? Is that not? And generally, I would say, on the above level, probably not. The question, though, is why are we even using a token? And so the issue is simply this: blockchain is not a particularly good or efficient medium or technology tool for storing data per se, because in blockchain, and that's why it's important to understand how the technology works, the entire database is replicated over and over and over again with each block. So it's not at all efficient. It's very costly to store data like that. So what we find often is someone will start with an idea that sounds really promising, but what they really get into is not quite like that. And that's why as lawyers, it's really important for all of you to kind of understand the underlying technology and ask probing questions of your clients. Say, okay, that sounds really interesting. Let's just talk about that a little more. How is this going to work? And very often what you'll find is, well, maybe we don't need blockchain technology for what you want to accomplish. And that's fine. That's not a bad thing. As blockchain lawyers, Angela and I spend a lot of time telling people, you don't need a blockchain for that. That's okay. But I think what you described probably could be affected in a way that would not trigger securities laws. I do want to talk about, we've got a fair amount of time left, but I do want to touch on a number of other topics. Just before we leave securities law, just one of the things that with NFTs comes up quite a lot, and that's fractionalization. So this was particularly kind of brought to the fore with the famous people artwork. Well, we said, we have one NFT, well, that doesn't feel like a security, but what if we divide that up into a lot of little pieces and then sell all of those, and we democratize? People like to use that word, democratize. Oh, how could be that? So, but if we divide that up into lots of little pieces and we offer everybody the investment opportunity to own a little piece of an NFT, and when it goes up in price, of course, you'll benefit from that. And that's why I spent all the time trying to do the background of the Howie Test to understand that. Now, when we look at that fractionalization through the lens of what are the principles behind the Howie Test, what are the principles behind investment contract, it starts to look a little different, right? And you start to say, well, hang on a second. You don't really, at least with a one-on-one NFT, you have a clear and identifiable consumable interest. I get to go to a bar and say, I own it. It's mine. I can put an image up on the wall. I can use it as my Twitter avatar, as many people do with their 40s and CryptoPunks and whatnot. And that's a consumable use. It's bragging. It's saying, look, I got a Rolex watch. I got a CryptoPunk. And those things. When you own a fraction of an NFT, you don't really have that. And once you take that away, you really don't have much, other than the ability to profit economically from an increase in the price. Now, you might say, where is the effort? Where are the common enterprise? And it's possible in many cases that there is no common enterprise in a fractionalization. So I wouldn't say that ipso facto, when you fractionalize an NFT, you got a security, bang, we're done here. Because the common enterprise element is very important. So if the person who fractionalizes the NFT does not retain a large interest in it, then you might say they simply don't have, you're not a common enterprise with anybody else. But these are facts and circumstances that have to be looked at very, very carefully. And certainly I would say, if you're thinking about fractionalizing an NFT, be aware that the SEC is going to be very aggressively presuming that you're creating securities. And so if you're endeavoring to do that and not comply with securities laws, you're definitely taking some risks. For sure. That doesn't mean that you're creating security, but it does mean that you're taking on regulatory risk for sure. I want to talk a little bit about AML and KYC in the context of NFTs, because it's really interesting. I think most of us, through our personal lives, not through our legal lives, are very, very familiar with e-commerce and how e-commerce works. So, you go on Amazon, you press buy now or swipe buy now, and it comes to your house. It's great. And, you don't really notice any KYC or AML going on. You go and you buy tickets to, the Wyoming football game, and nobody's KYCing you. You do all this online commerce, and nobody is bothering to get information from you. And so, if you're selling an NFT, you say, "Oh, it's the same thing, right?" And it would be the same thing if you purchase the NFT in the same way you do your other online commerce, which is with a banking partner, with a money transmitter, with a credit card provider, most likely. If you do, then there's already KYC and AML taking place, because if you have a credit card issued by whatever's the largest bank in Wyoming, then they have your identity, they know who you are, they're monitoring you, and they can determine whether this particular transaction is run in their company. For example, holding aside your credit limit, even if you had a high credit limit, if you're buying an NFT at the maximum of your credit limit, you might get flagged, even if it's not otherwise problematic, because they have systems that monitor the activity of their customers. However, if you're selling NFTs, and you're selling them and you're saying, I'll accept crypto. So my price for this is 0.02 ETH, my price for this is so many DAI, my price for this is so many USDC, and you're getting and receiving the crypto directly from the wallet of somebody that you have no idea who they are to your wallet. You're sending them the NFT that you sold. You don't know who you're transacting with. And that raises any number of problems. If you're not in business yourself, then you're not a financial institution, and you don't have the kind of what we call Bank Secrecy Act or PSA requirements that apply to a wide variety of financial institutions and entities that are like financial institutions. However, that does not necessarily let you off the hook, because if you're at least a US resident, you're subject to all of the sanctions rules that apply to all of us here. And sanctions are a very important part of our government's policies. We saw that, most recently with Afghanistan. And, sometimes things happen outside our borders, and we're very upset about this as a country. And economic sanctions are one of the most powerful tools that we have. Once economic sanctions are in place, all US persons are prohibited, pretty much without exception and without any de minimis limits, from having any economic relations with either the country, the identified individual, or very often sometimes just people who own interests in an identified company. So in many cases, sanctions apply not just to a problematic company, but to somebody who owns more than 50% of that company. That can be very difficult to know. So if you're doing business with a wallet, and the only thing you know is an ETH address, then you don't know who's on the other side of it. You might reasonably say, well, it's unlikely Kim Jong-un, and his niece and nephew are, the people that I'm dealing with, but you don't know that. And so KYC is something that you have to examine on a case-by-case basis. If you are running a platform, then it's something you have to look at very closely. And certainly, I think increasingly, the NFT platforms are building KYC into their programs to try and address these issues. There are also changes to the BSA that I think come into effect next year, 2022, that will bring art dealers and quite likely, when the dust settles, NFT sellers into the scope of the BSA regulations. At that point, if you run a business in the NFT space, you may well have formal obligations, not just informal obligations that apply to all of us, generally citizens, but quite formal obligations. So KYC and AML is something that needs to be taken very seriously. The challenge, of course, is that, when we work in the crypto space, people really appreciate the privacy. And privacy is a valuable right that we all respect. How these get reconciled is very, very challenging. I wrote an article about this. Anybody wants to see it, it's up on our website in the context of DeFi and how do we balance these two things. But these are fundamental questions about, privacy and the public safety. I want to talk a little bit about secondary trading of NFTs because, again, one thing that people really like with NFTs is the ability to trade and engage around that. And one of the challenges with an asset as unique as an NFT is pricing. How do you know what an NFT is worth? You could set a price, but your guess as to what the price is worth may be markedly higher or lower than other people's ideas, and it may either cause your NFT not to get resold, or alternatively, for it to be sold for much less than it was worth. One thing that people like then is the auction structure, right? So let's see what the market says something is worth. And that's a great tool to use. However, a number of states do have laws that relate to auctions, including to online auctions. And so, again, as people drift into crypto, sometimes they think, I kind of do whatever I want, crypto, And in fact, there are laws that apply to this. So it's very important if you are on a platform and doing an auction, you've evaluated, is the platform licensed to run an auction? Do you need to have a license? How does that apply? So that's just something to think about. The other thing, just again, when you're dealing with NFTs, you have to be very aware of is tax. Not just the tax you earn when you profit through business, but sales tax. And so after the Wayfair decision, which is now 4 years, 5 years ago, the Wayfair decision was, state tax became much more complicated. Generally speaking, prior to Wayfair, state tax was applied from the jurisdiction from which you worked or sold. But with all the online commerce, that's changed. I am far and away, not an expert in state sales tax, but I know that post-Wayfair, online sales have gotten much, much, much more complicated. Which states have a nexus with the transaction and which states have a right to charge the sales tax. Depends on factors like, do you have a place of business there? Where are you selling from? Variety of factors. This gets exponentially more complicated when it's not physical goods being sold, but a digital asset. There are exceptions in some states around some non-physical assets, for example, music downloads. So popular things. You're buying music download, how and where does state sales tax apply? But most of those rules don't necessarily address tokens, which are, again, as we said before, you're not actually buying the art, you're not buying a book, you're not buying image, you're not buying a music file, but you're buying is simply a digital asset that points to a music file. And so how that applies on a state-by-state basis is very complicated and just needs to be worked through with your platform. Also, the US has one form of collecting state sales tax, which is at the point of sale. But of course, many other countries, most notably the member states in the European Union, have a very different system, value-added tax, at which the tax keeps getting added along the path until the final and ultimate consumptive sale. How that applies in Europe is its own, difficult and tricky sets of issues. So these are all things that come up when you sell NFTs. So I want to leave just a couple minutes left if there are questions or comments or any discussion before we have to wrap up. So,
as we have blockchain scalability happening and we move to a place where you can put, say, the highest resolution file inside of the NFT, how that you've referenced, if only the owner could view the highest resolution and everyone else can, it's always there. It's part of the ledger, but it doesn't go away. But only the owner has the highest resolution access.
Right. Well, there's two parts to your question, which are great questions to repeat for people in here. If we could embed in the NFT itself, in the smart contract code, a very high resolution copy of whatever it is, let's just say an image to keep it simple, and others might have a lower resolution image, which would be not quite as good, is that a way of both distinguishing the NFT and adding something? And it's certainly an intriguing idea. As we said before, for many blockchains, not all blockchains, and some of the newer blockchains are trying to address this by being more oriented toward proof of stake and having lower costs. But you still would have to store the high resolution file as part of the smart contract code, potentially replicate it and pay a lot of cost for doing that. And then again, you get to the question of who's bearing that cost, right? So that's another factor to take into account. But certainly, and I think your question, its implication is a point I really want to make, which is being computer code, there's no limit, more or less, to what you can do with NFTs. You can code all kinds of things. You can have things that are mutable or changeable. For example, the geographic location of the wallet or where the IP address that's associated with the wallet could change what the actual NFT points to. So as you move it around, it can point to different things. It could change over time. It could be added to. There's, and people are just starting to explore the design palette. So, different resolution copies could be among the issues. I would just last add on resolution that it's very hard to prevent the high resolution copy from not being replicated. So if I'm the owner of the NFT, conceivably I could make multiple copies of the high resolution image and then distribute those, legally or otherwise. So there are interesting questions, but that's a great question. Other questions?
So how do you recommend going about verifying the actual rights in the seller? Is there
That's very difficult. It's a great question. So again, to replicate, to repeat the question, how does one, in buying an NFT, know that the person that you're taking your rights from, as limited as they may be, actually have those rights to give? And it's very difficult, is the short answer. Most good platforms do require representations that whoever is ostensibly the creator has all of those rights. But implied in your question is but how do you know? And you don't really. And in many cases, if you're buying from some random creator, you have no practical recourse. You've sent them, $10,000 worth of ETH. You're never going to see them again. So it's hard. It's a tough question. In the back.
Yeah, I want to go back to the beginning of your speech. Would you say that smart contracts are needed for NFTs?
Yes.
Are you familiar with the Cardano blockchain?
Yes.
You know the difference between the UTXO and like account-based models?
The Cardano blockchain, I understand, is in the process of developing some interesting technology. I don't know where that stands.
So actually, NFTs were available before smart contracts ever came out. Developing smart contracts to make NFTs.
I am broadly familiar with it, and I would be delighted to be more educated on where the Cardano project
Would you say that
stands.
lawyers need to know the difference between the chains and like maybe they should specialize in chains? Or would you say that like
particular chains?
Yeah.
I know that the Cardano chain is in the process of developing, and I am always eager to learn more about where all the different chains are at any given points in time. Sir.
Last week we saw at OpenSea where the head of product, Mr. Chastain, sort of front ran his clients and was getting pre-access to before the public did to certain offerings. So the mainstream media calls it insider trading and he's asked to resign. Does he really have any criminal culpability? I'm sure he'll get an avalanche of civil suits from purchasers, but is it really insider trading or is that just an easy analogy to make? It's not really there.
It's a great question. It was a widely repeated story that a head of product at a very popular NFT platform had access, at least it's been reported, had access to the NFTs that would be listed on the front page of the platform. Those obviously tend to sell more than those that have to be searched for. And that knowledge allowed the individual to acquire the NFTs in advance of them being on the front page and therefore profiting by a resale later. This is a complicated question. I don't believe there's necessarily criminal liability there. Certainly at a minimum, the reputation of the platform was damaged. I think that's the easiest call to make. I think lessons were learned along the way. And hopefully, it's something that all the platforms are going to try and address. There was a very similar issue about 10 years ago in the area of daily fantasy sports, where employees of one of the two major platforms had knowledge of what was going on. They couldn't take positions on their platform. They went to the other platform and took the positions, but they used inside knowledge of where things were going, and that also created a big stink. And I think people learn lessons. The other gentleman just
So, if an NFT is going to be it's considered a security for any reason, would the minter of the NFT have any remaining fiduciary responsibility to the purchaser of the NFT. The reason I bring this up is because I don't know if you've heard about the hashtag Free Hawaii Photo project, where a photographer made a one-of-one NFT, sold it for $300,000, and then turned around and dedicated the image to the public domain, i.e. basically nuking the value of the NFT, at least in my opinion. So what further responsibility could there be once you, if it's not a security, I can see there being done, but if it is a security, doesn't that potentially create lingering problems for the minter of
It doesn't sound like a securities question to me, but it does sound like a fraud question. And if there are stated or implied warranties about the way in which something was sold, and again I kind of alluded to this very much toward the beginning, that when if you're accepting $300,000, there's at a minimum an implied warranty that you're not going to do something like that. And I would have thought there's if a lawyer could recover money from the seller, they'd have a pretty good position. So last question. Go ahead.
So this is kind of related to his question. It was on the issue of persistence. So if do you have like a recommendation for if people are selling something like that, like artwork, like what you would say is like a statement of like the persistence? And
I think it's a really tricky issue especially when it's a sort of individual creator as opposed to a business, because the individual creator just doesn't have the means to pay for that. There are new platforms coming online. It sounds like you're very up to speed, so you're probably familiar with Arweave and eSwarm. And both of those promise to allow permanent persistence or functionally permanent persistence for a pay one price. I do believe I've got friends at AWS, and they are also looking at a pay one price solution for permanence. So both on a centralized basis and a decentralized basis, there may be theoretical solutions. I think the practicalities, though, are that that's going to be priced for most people that are not business platforms, priced at a point that just don't really make practical sense at most times. I think for those who are buying an NFT for a long posterity, they'll probably want to ensure their own persistence independently, and ensure as and when they want to dispose of the NFT, that it still can be, the resource can be still found in the URI as in the code. So again, there's not a bust reference, but I think people are going to deal with that differently. I think we're probably going to wrap up now. You've been great. You've had great questions. I really enjoyed talking to all of you. So those questions.